Okay, we're live. Hi everyone, it's Ray from BitChute, and today I'm here with someone who needs no introduction. It's Amy Peikoff, who was the Chief Policy Officer at BitChute and is now doing also more important free speech and privacy and constitutional protection work at Pacific Legal Foundation. So Amy, it's great to speak to you again. Always a pleasure, and welcome back. Could you tell us a bit, for viewers who don't know, about Pacific Legal Foundation, the sort of work that they do and your role there?
Sure. Thanks for having me back, Ray. It's always great to be able to speak with you. I am at Pacific Legal Foundation, as you said. I'm not doing free speech work per se, although I think sort of our rights are interconnected, especially that privacy and free speech have a lot of interplay. But I am specifically focused on Fourth Amendment rights, and in particular, bringing property-based and contract-based concepts to bear on the protections that we get through the Fourth Amendment. I'm not sure if you're familiar with Justice Scalia's opinions that are relevant to this topic. There was a series of opinions. There was one called Kilo, K-Y-L-L-O, which involved the training of a heat-seeking device onto a home. And then there was a United States versus Jones, which involved the attaching of a GPS device to someone's automobile, the bottom of the automobile, tracking it around. And then there was Florida versus Jardines, which had to do with, I believe, a drug sniffing dog on the porch of an apartment, sniffing in the area, and the property protections. It was a property-based concept that Justice Scalia was working to bring back into Fourth Amendment jurisprudence, and that I think is right based on my own scholarship in privacy for many years. And so we are trying to build on that in expanding, or really I would say reinstating, the protections of the Fourth Amendment to persons, houses, papers, and effects.
That's fantastic. And it's so important that organizations like this exist, of course, right? Because ordinary people who come up against these challenges have so little resources compared to governments, and organizations like Pacific Legal Foundation can help support those cases and defend the rights of individuals and therefore defend the rights of everyone. So I think that's fantastic. But
yeah, that's right. When we take cases, by the way, we free of charge, by the way. We don't charge attorneys' fees to our clients. And I think that does make it possible to vindicate rights that might not otherwise be able to be vindicated.
That's great. That's so important in order to preserve everyone's rights. And today we're here to talk about another important case that you're currently working on, which is a person called Wilmer Chavarria, a US citizen who lives in Vermont. And I can just set this up a little bit, and then perhaps you can take it over and tell us about this. But my understanding is he arrived at Houston Airport in order to visit his family, and he was detained for over 4 hours, and his devices were seized and searched. And this is something that goes on quite a bit, and this is something that US citizens shouldn't perhaps have to put up with. And perhaps you can explain and set the background for this a bit better than I have.
Sure. Now, this is a problem that we've known about and that many other people have known about for a while. I think it's only really been talked about a lot in the media over the last year or two, perhaps. There was an Atlantic article about it. And, I think because of the increasing frequency with which Customs and Border Patrol and potentially ICE, which also is authorized to do these types of electronic device searches at the border, those have been increasing dramatically over the last years. At Pacific Legal Foundation, we have issued a policy explainer just showing in graphical form the increase in the number of electronic device searches. And again, these are warrantless, suspicionless electronic device searches conducted at borders and at ports of entry over the last, I don't know, well over a decade now. And just to give you one figure, between 2015 and 2024, the number of such searches at the border has more than quadrupled. So it went from about 8,500 to, I believe, over 46,000 in that period of time. And the fiscal year 2025, which just ended recently for the government, in that year, there was 55,000 plus of these device searches at the border. Now, Customs and Border Patrol has taken a little bit of a step back in recent years and said that if they're going to do the most intrusive type of these searches, where they will attach some sort of device to your device and offload information from it or scan it in certain ways. Of course, we don't know exactly what they do, right? If they're going to do that, they say they have to have reasonable suspicion and the approval of a supervisor. So there's still not any impartial arbiter. There's no judge that they have to go to get a warrant or any type of process at all. It's all within CBP, as long as the supervisor gives the okay and you articulate something that they write down, I guess, in a record amounting to reasonable suspicion that they can do this. With respect to our client, Wilmer Chavarria, he is a naturalized U.S. citizen. He's been naturalized since 2018. He's had legal status within the country for longer than that. He came to the United States on a student visa in 2008 to go to college and has been living here in different capacities ever since. He is now a successful educational professional. He has graduate degrees from University of New Mexico as well as Harvard University, and he's a school superintendent in a school district in Vermont. He was visiting his family in Nicaragua, which he does regularly and has done regularly for all this time. And for the first time, he was detained and brought into some kind of creepy, intimidating back area at the George Bush Intercontinental Airport in Houston. And he was interrogated for hours. And after a number of hours, he actually gave up and gave into the demands of CBP or whoever else was there and handed over the passwords to his devices, which they actually had taken from him early on in the interrogation and detention that he suffered there. But they never gave him any cause. They never told him the reason that we're doing this is this, or we think that you are suspicious because of whatever. The only thing that they told him that made him suspicious is the thing that I found particularly breathtaking, which is that they said he was suspicious because he asserted what he believed to be his Fourth Amendment rights. And I found that stunning. They said, you don't have Fourth Amendment rights here. You don't stop talking about your Fourth Amendment rights. What are you, a lawyer? They asked him, etc. And all he is a well-educated, conscientious education professional who felt compelled to try to protect the student data on his devices. And so was standing up for his rights, the privacy of his students, etc. And because of that, they said he was behaving suspiciously, that they were potentially going to report him to the FBI, that he was going to be in danger of not working again, et cetera, et cetera. And we just found that breathtaking, unbelievable. And given that we had had attention on this issue already, we were happy to have him as a client, and so that we could actually try to vindicate not only his rights, but hopefully the rights of all Americans and get these policies set aside.
That's incredible. I mean, that someone protecting their own rights and thereby protecting everyone's rights is seen as suspicious. That says a lot about the culture at these organizations, that's the way that they think. And, that creates a chilling effect, so that everyone who sees this, or not everyone, but many people who see this sort of persecution going on will then not resist, and that's perhaps what they want. But I mean, I think everyone's had bad experiences going through DHS, through TSA, Transport Security Administration. You have to wonder about whether they're protecting our whether they're keeping us safe, or whether they're just there to keep us under control. For example, I saw a thing years ago where someone went through. Sorry, there was a test done on TSA to see how effective they were, and undercover operators went through TSA trying to sneak fake explosives through, and out of the 70 tests, do you know how many actually got through?
Oh God, I forgot. I
Take a
remember
guess.
reading about this, but I forgot the number. What is it?
Yeah. No, it's 67 got through, so not very effective, not keeping us very safe, and a 95% fail rate. So I think even one guy had like a fake bomb strapped to his back, went through, set off the metal detector, got patted down, and they still didn't find him. So I'm very skeptical about all these things to keep us safe. Yeah, it's really, really incredible when you look into it, whether it's more about control or whether it's about safety. I'm very skeptical about it.
Speaking about that safety issue, if that's okay. So one reaction that we have gotten since we filed this suit and then publicized it out there on social media, there were a number of people who are saying, oh, there is this traditional border exception. It's there for good reasons, that they need to actually search things to be secure. You, Amy, must be in favor of allowing Chinese bombs to come through the border or whatever like that. So to be extremely clear, what we are talking about is the contents of these devices. I don't, myself have a problem with Customs and Border Patrol actually looking at the device and seeing whether the device is a bomb. That it's really actually an electronic device that is a cell phone, et cetera. So some sort of cursory looking at the physical object to make sure that you're not trying to smuggle in weapons. I'm not much myself for the drug laws, but given that there's contraband, they could look and see that the physical contraband to which the traditional border exception has always applied, make sure it's not there. Okay, fine. But what we're talking about are electronic devices, in particular their contents. Our Supreme Court in the United States back in 2014 in a case called Riley versus California recognized that law enforcement, if it peruses the contents, particularly of cell phones, right, which are the personal devices that we carry everywhere and do everything with these days, you look through the contents of this device and you learn more personal information about a person than if you had conducted a search of their entire home, right? And the Supreme Court, recognizing this fact in 2014, decided that a traditional exception to the warrant requirement, which is known as the search incident to arrest exception, that it does not apply to cell phones. That even if law enforcement has arrested you, presumably for good cause, right? They would have probable cause to arrest you. Nonetheless, they would have to get a warrant to also search the contents of your cell phone.
Right. Okay. Yeah, that makes perfect sense because, you're effectively carrying documents on this cell phone, right? It's not like your luggage. They're not rummaging through your suit and your underwear and your toothpaste to look for things in your bag. So explain a bit about that, because like how does the Fourth Amendment apply and what is this exception? Like why did it originally come about in order to what was the reasoning behind it originally coming about, and how is it different to how they're using it now?
Right. So, some people have different theories about what legitimate interests governments have at the border. And, those of us who do believe that there is sovereignty, that maintaining a border and having some sort of security screening at the border is a proper thing, you would say, okay, we want to make sure that they're not bringing in weapons, that the people are not terrorists, they're not people who are part of a enemy force with which we're at war and they're coming in to try to destroy us, right? We're going to maintain security at the border. There are some additional things, right? There's customs and duties, right? They're going to charge certain tariffs at the border. Now, as a free market person myself, I'm not a fan of that, but that was part of the traditional rationale. And then, of course, contraband And contraband could be anything from something that a government legitimately needs to keep out for security reasons to something that maybe someone who's more libertarian or objectivist mindset would say, okay, these drugs should be legal. We shouldn't consider them contraband. They could come in through the border. But in any event, those are the things to which this traditional border exception has applied. And if you note, they are all physical objects. They are not digital files, you know, your documents, your communications, your personal photographs and other media, et cetera. That is not what was encompassed by the traditional border exception. And yet, Customs and Border Patrol and Immigrations and Customs Enforcement both have directives that they have said, oh, they just fall right under this traditional exception. Nothing to see here. It's the same. And yet, again, we have the Supreme Court acknowledging in 2014 that when you carry this thing around, you're in effect carrying your home, the equivalent of your home in terms of privacy interests. And so I would say that it is natural to assume that you would take the rationale from Riley versus California and transfer it over into evaluating the directives from Customs and Border Patrol and Immigrations and Customs Enforcement, and that you would declare them unconstitutional insofar as they are allowing warrantless, suspicionless searches of the contents of these devices, also laptops and tablets, et cetera, that people carry all the time. But as it is right now, Americans are being forced to make a choice. If they're going to travel internationally, they can choose to travel with their electronic devices and all the convenience and productivity and everything else that they offer, you know, staying connected with family and friends and sharing on social media and perhaps speaking out on issues that are important while you're traveling too as well. These are all inherent rights of being an American citizen. And yet we are being forced to choose between that or giving up your Fourth Amendment rights entirely, because in their view, you are actually obligated, that word is used, you are obligated according to CBP and ICE to, upon request for any reason or no reason at all, just hand over the device and what they call the keys to the digital kingdom, which is the passwords, all the passwords to get in all the apps. And in Wilmer's case, when they finally did search, and they did so only because they gave him assurances that they were supposedly not going to go into the student files. But he doesn't know one way or the other whether they did, because what did they do? They took the devices and the passwords, they took them into another room out of his sight and did whatever they did to them there. So who knows what they looked at? Who knows what they downloaded? Have they uploaded the information into a huge government database, which we know happens? CBP has acknowledged that that happens, and that in some cases they are storing information in databases accessible to thousands of Department of Homeland Security employees for up to 15 years. Imagine all your personal data ends up in some huge government database, is stored there, can be perused by thousands of DHS employees for up to 15 years.
Yeah, and I know at the start of this year, around March, I think actually, President Trump created a executive order where I think it's called eliminating information silos, where he allows for different departments to share that information. So that's even more dangerous, because once you have information from the border and you also combine that with information from your finances and from your health and from your education, you can really build up a profile about someone that becomes, you know, an all-encompassing profile that you can use to find all of the pressure points to apply any sort of pressure to them that you like. So I can totally see that. And yeah, I also heard that there's like 100-mile zone. Is that right? That there's it's not just at the border, but 100-mile zone, which seems crazy to me, because it doesn't that like cover a lot of the country?
Yeah, so this is the subject of another policy explainer that we have at Pacific Legal Foundation. So if anyone wants to go and go to pacificlegal.org, pacificlegal.org. You can find all these resources that I'm talking about. But we have another policy explainer aside from the electronic device search explainer that covers specifically the 100-mile border zone. And it's right. It's exactly this. From any border all the way around the country, so the coasts and everything, 100 miles within there, they claim the ability to do these warrantless searches that we've talked about, and other types of intrusive searches where Fourth Amendment rights are either reduced or don't apply at all. And that zone actually encompasses about 2/3 of United States population, because of the big
Wow.
cities, et cetera, that are, are in that ring around the United States.
So someone technically in their house right now, I mean, they're probably not doing this right now, but if they wanted to, they could pull up to someone's house, knock on the door saying, hey, this is an authorized border search because you're 99 miles from the border, and they could say, hand over your devices. They technically, wow. So this is really important then, because most people probably don't know that 2/3 of the population, you say, are affected by this and could potentially be asked to hand over their devices.
Whole city of Los Angeles, for example,
Wow.
Miami,
Wow.
right? So probably New York City. Just go in there and have at it, right?
Yeah, and going back to a bit what you said before, I mean, it totally makes sense to me that these are personal letters and documents, because, I mean, anything that's on your phone or on your computer, you can print out, right? And you could carry it through as a document. But the same document just being digital, all of a sudden they claim to have rights over it. So I think you're absolutely right about that, just from my layman's thinking about it. That anything that can exist digitally can exist on paper as a document. But what remedies are you seeking for this? How can you fix this?
Yeah, so what we've done in order to really put a focus on the issue that matters the most, which is the unconstitutional nature of these policies and the urgency of changing them, setting them aside in some way, what we are asking for is, through the Administrative Procedure Act, for the court to declare the policies unconstitutional, therefore unlawful, and therefore they have the authority to set them aside under the Administrative Procedure Act. Separately, you could examine them under just the Fourth Amendment, using the court's inherent powers to do that, and again, declare them unconstitutional. You could put an injunction on CBP and ICE as well, right? Because they, as I said, have a similar policy. Theirs actually allows any kind of search, no matter how intrusive, with no reasonable suspicion, whatever. But yeah, we're asking for both of those policies to be declared unconstitutional, set aside, and potentially an injunction to stop them from enforcing those policies, both on our client, Wilmer Chavarria, but potentially a broader injunction that would prevent them from enforcing them generally on Americans.
That's great. And what would be the effect if you win this case, and one if you lose the case, on ordinary Americans?
So if we win the case, of course, the great thing would be potentially we're setting this aside. We're at least setting a precedent, even if the court decides it has only the power to issue an injunction as applied to Wilmer Chavarria, which some people think might end up being the case. It's nonetheless going to set a precedent, and I assume put CBP and ICE on notice that they could have some legal trouble if they continue to enforce those policies against other people who, for example, seek monetary damages. We're not seeking monetary damages for what happened to him, as horrific as it was. We're not seeking that in this case. We're simply seeking the declaration that these policies are unconstitutional and that they be set aside. But yeah, that would be fabulous. If we end up losing the case, then I would assume that it would send a memo to everybody who believes that that outcome is wrong, that something needs to be changed, perhaps legislatively or otherwise, right? So that would not, even if we ended up losing this case, give up on the fight to change these policies, because they are wrong. There's a number of leading scholars in the Fourth Amendment space who agree with us, who think that, just as the Supreme Court in Riley versus California declared that the search incident to arrest exception did not apply to the contents of the digital devices, similarly, they believe that the traditional border exception should also not be applied to these devices. That, the government is sort of getting lazy. They say, hey, if we just wait till this guy goes through a point of entry, and again, it doesn't matter whether you're coming in, from a trip like Wilmer Chavarria was, he was coming home from visiting his mother in Nicaragua. It doesn't matter whether you're doing that. In some cases, people are leaving, they're on the way out, and probably law enforcement has enough information on these people already to get a warrant, but they just decide not to. Instead, they're going to take advantage of this border exception and intercept them at the airport and take liberty to search everything that they want to, simply because they have this directive in place and they've, recited the incantation of traditional border exception enough times to make themselves believe that it's right what they're doing, but they're not. It's not right what they're doing.
No, it isn't. But their counter argument to this would be, as it so often is, that this is a matter of national security, so they have to be able to do this. Could you explain a bit about that and why that's wrong?
Yeah, no, this is not a matter of national security, because I don't care, Apple has increased the carrying capacity of these devices up to 2 terabytes. The most recent iPhone can carry 2 terabytes worth of data, and that just raises another issue, which is that if you upgrade your device because of the quickly increasing storage capacity of the devices, when you upgrade, you don't have to give up all the old data that you have on your old device, whatever, however many years worth of personal information and old photos and everything. You just load it onto the new device, and now you're carrying even more years of information with you, right? So it's just a tremendous amount of data. As big as that is, however, you are not smuggling contraband weapons. You're not smuggling illegal immigrants in your electronic devices. All the physical things to which the traditional border exception applied, and which at least some of them have legitimate security interests attached to why they can search those things, none of them are in the contents of these devices. There is such thing as digital contraband, but it's a very minor percentage of the information that's carried around on electronic devices, and it doesn't pose any immediate danger to anybody. So we can chalk up any need to, quote, look at your electronic devices to search for that as either Orwellian in scope and therefore unreasonable, or it's traditional law enforcement purposes, and therefore, again, what do they need to do? They need to get a warrant to search the contents.
Absolutely. And this has always struck me as odd, because in theory, anyone wouldn't need to carry the data across the border. They could just get to the destination and download it. We've got the internet. We've had that for a while. Everyone understands how downloading works. So there doesn't seem to be a need to actually physically carry data across the border, to me anyway, at least.
Yeah, I mean,
so
and especially with
with
insofar as you have end-to-end encrypted communications, especially, or any sort of encrypted cloud storage that you can do, no, there isn't a need to carry it physically across the border. It is true that occasionally someone will physically carry across the border a digital contraband, but it's in such a low percentage of cases that it is not at all reasonable to say that you're going to search without any particularized suspicion every single American citizen and look through their entire personal digital life, which is basically all encompassing these days, in order to root out this very small percentage to in fact do law enforcement. And if they believe that that is legitimate, for this like tiny issue of digital contraband, to subject everybody to just searches all the time without any particularized suspicion, we may as well just implement Orwell's 1984 generally and be done with it, because then there's just no pretense whatever if they're really trying to defend this, in my view.
That's right. Innocent until proven guilty, right? And people at home, how can they help with this? How can they help your case, and how can they push back against this in general?
So in general, you could share news about the case, of course. If you have the means, we are always happy to get donations at pacificlegal.org to help with this litigation, because of course it does have costs, and we are not charging our clients, as typical. We don't charge our clients any attorney's fees. So at pacificlegal.org, you can give a donation. You could read all of the resources. As I said, we have a couple of policy explainers. They're just a couple pages each with graphics explaining the nature of the border search and the extent to which it applies and how it's grown over the years, et cetera, grown in use over the years. So, check out the resources there, definitely.
Fantastic. And I would also say, as someone who's from the UK, I'm constantly worried about traveling with data. As you've probably seen, the UK's become quite authoritarian in this regard. So I tend to travel light on data myself, and download at the destination in order to have anything that I need, which is, just ordinary emails, nothing like contraband, but just so that when I am
just to have some privacy, right? Just to have some privacy.
To have some privacy, right? Because no one should be able to just go through all of your diary and all your personal artifacts whenever they want to. That's completely unacceptable in my mind, and I think to all of our viewers as well. So hooray for privacy. So thank you very much, Amy. Is there anything I missed? Is there anything else you would like to say?
No, I mean, you touched on one topic that we might have talked about a little bit, which is that given the nature of the policies as they stand, which is that it's CBP's and ICE's view that if they ask when you're there at the port of entry or in a border zone to see your devices, you are obligated to hand them over with their passwords. That is their view. And if you resist, as Wilmer Chavarria tried to do in Houston Airport, you are going to be detained, and or your devices are going to be taken from you, and they can keep them for up to 5 days, but then they can get extensions, et cetera. If you read the CBP directive, you can get all the details, but they will, use their best forensic equipment, whatever it is, to get the data off the device. This is something that you are not able actually to resist right now. So what are Americans doing? And it sounds like people from the UK are also doing this as well. You are bringing a device with you that is what some people would call a burner device, or maybe you are offloading all the data of your regular device in advance of going through these ports of entry and then loading it back on again on the other side. They are taking steps so that they actually, when they go through, they do not have a device with anything interesting on it that they want to see. And I've heard stories, that in some cases, these agents are perusing them and even making tasteless, inappropriate comments about the contents of the devices. Can you imagine how humiliating that would be? So to avoid this, as I said, they say it's only a small percentage of people who go through that actually get searched, but that's not much comfort if you know that it actually could, as an American, and especially as someone coming to the United States from a foreign country, could definitely happen to you. And in order to avoid the intrusive, search, the embarrassment, everything else, people are coming with devices that don't have anything on them as they're going through.
Yeah, I support that. I think that's a good idea. It's unfortunate that we have to do that, but until we have remedies to these problems, I think it's a good idea for people to do it.
Yep.
Thank you so much, Amy. And where can people reach you?
Again, at pacificlegal.org. So if you have a case in which you believe that government is violating your rights, we have a claim intake form at Pacific Legal that you can fill out. And it's not just for my practice group. I have a Fourth Amendment subgroup within the property practice generally. So there's takings cases that we've done, quite famously in some cases. And then we also have an environmental rights group, in the sense that we are fighting back against government environmental regulations that prevent unnecessarily productive uses of land. We have an E&O group, Equality and Opportunity Group, in which we fight back against government discrimination on the basis of race and other characteristics. And then we also have a separation of powers group, which I'm actually sort of joining with in my Fourth Amendment case, because they use tools like the Administrative Procedure Act to hold government agencies accountable. And so anytime that a government agency is violating your rights, it might not be a Fourth Amendment right, it could even be a free speech right, et cetera. We at Pacific Legal want to hear about that and potentially consider taking your case.
Fantastic. I'll put those links in the description below for anyone who wants them. And I hope you come back again soon to talk about updates to this and any other cases.
Okay, great. Thanks, Ray.
Thanks, Amy. Bye.